I'm Pam Masters. I'm a collaborative family lawyer and mediator. I guide couples on the difficult journey of divorce without court involvement. I do this to protect children, preserve financial assets, and obtain better outcomes for my clients. Often my clients come to me and ask if they can get full custody of their children. So what's the deal with full custody in Florida? Well, first of all, Florida doesn't recognize custody anymore. We don't use the word custody of children. In Florida, the idea of custody is broken down into two separate components: parental responsibility and time sharing. Parental responsibility is about making major decisions for your children, and the public policy in Florida is that the parents will do that together, what we call shared parental responsibility, so that each parent will confer with the other and they'll try to reach a mutual decision. Time sharing is about the schedule that the children will spend time with each parent. These two concepts together make up what we used to call custody. So, can one parent get full custody of the children? That is, have sole decision-making authority and all of the time with the children? Probably not. You see, the strong public policy of the state is that children should have the benefit of a robust relationship with both parents, and that both parents should share equally in the joys and responsibilities of child rearing. This means that absent compelling evidence, the court's likely to award shared parental responsibility and more or less equal time sharing with each parent. Every case is unique, of course, and what the judge does in one case or what one family or another is doing is not relevant to your family or your situation. And the judge has to do what's in the best interest of the children. If you want full custody, which is sole parental responsibility of your children, what you're telling the court is that the other parent poses an imminent threat of harm to the child. You have to prove abuse, abandonment, or neglect, that it would not be in the child's best interest to spend any time with the other parent or to have the other parent involved. And here's the thing. The judge who oversees the case may have presided over thousands of cases in his or her time on the bench and has a very wide and deep perspective. He or she sees the very best of parenting and the very worst of parenting. So what you consider to be abuse or neglect is not likely to seem so extreme, of course, depending upon what it is, from the judge's perspective. Let me be clear here. We're not talking about drug use disorders, domestic violence, or other criminal or dangerous behavior. But I hear every day from outraged parents about the awful things the other parent is doing to the children. And these anguished parents seem to feel that what is going on is as bad as something that is clearly dangerous or deleterious to the children. However, many times those awful things, while truly upsetting to the parent recounting them, are not objectively awful in the legal sense. I'm sure it will come as no surprise that different people parent differently. And some parents feel passionately that their way is preferable and the other parent's way is abusive or dangerous. But when I dig a little deeper, I often find that the parenting differences are differences in values around things like what foods are healthy, how much screen time is appropriate, what are the consequences for bad behavior, how late should a child be staying up or sleeping in, things like taking away the cell phone at bedtime, restricting junk foods. You get the idea. As a parent, I completely understand how passionate we can feel about some of these things. As a family law lawyer, I can assure you that none of them rise to the level of justifying sole parental responsibility and no or minimal or supervised time sharing with the other parent. As a parent, I completely understand the worry that comes with things like unsupervised social media consumption. As a family law lawyer, I can assure you that this is not something that will cause a judge to deprive a parent of rights or responsibilities for their children. The hard truth is that every parent gets to parent how they parent. It is best for the kids that the parents have consistency across households about things like bedtimes, whether the cell phone will go to bed with the kids, what social media apps the kids will have access to, consequences for the breaking of rules, even some of the rules themselves. Yes, beyond any question, consistency between homes is best, but it's not always possible, or not possible about every issue. What I know is that the most unhealthy co-parenting happens after an adversarial process, where one or both parents are trying to portray the other as unfit in some way to a judge. This leads to a lack of information sharing, the kids becoming secret keepers, and no communication about consistency, so no possibility of agreement. This harms children. The best co-parenting relationships emerge from a collaborative divorce, where an open conversation about parenting styles and new family structures occurs in a safe environment. All of a parent's concerns can be addressed with a neutral expert who will guide the conversation and the decision-making around the parenting plan. Choose collaborative for your kids' sake. I'd be happy to talk with you about this more. You can reach me at 386-271-8044 or shoot me an email at pam@masterscdc.com. There's tons of great information on my website as well at www.masterscdc.com.